Hi guys, Stan Campbell, COO and co-founder of CCW Safe, and this is the CCW Safe podcast. Today I have a couple of special guests with me, Don West, a National Trial Counsel, and Shawn Vincent, our litigation consultant. We're going to start covering a four-part series to deal with members' questions, and we're going to get right into them. I'll go ahead and read them right from here so that I don't miss anything for you guys. So, gentlemen, let's first start off. We're going to cover a few topics within this series, but the first thing that one of the members would like to know is to give us a true understanding of the concept of reasonable belief.
Mm-hmm. Well, most everyone knows what belief means. I take it essentially to be you sincerely hold something to be true, for you anyway. So the real issue is what's reasonable belief. And of course, in the context of self-defense law, you have to have a reasonable belief, a reasonable concern, a reasonable fear that you are facing an imminent threat of great bodily harm or death. So the key term, I think, and one that permeates the entire self-defense process in court is what's reasonable. And actually, that's kind of complicated because reasonable is typically defined in two ways. One is what's reasonable to you, and meaning as you explore the context in which you're being challenged or threatened or confronted, is your perception of it reasonable to you? Are you holding a good faith belief in what you're seeing? But the second part is more objective, and that is, what is the jury or the judge or some other person evaluating your conduct going to think? So reasonableness in the context of a self-defense claim is both your perception of what's going on and also whether the third-party observer, the jury, also thinks that what you did was reasonable. And in order for them to figure that out, they're more likely to think about what they would do in the same situation. So they'll decide, was your belief genuinely reasonable? And then was it reasonable from the third party perspective, meaning was there a threat that you reasonably perceived to be significant and life-threatening? And then was your response to that threat also reasonable, subjectively and objectively?
Gotcha.
We covered a self-defense case where the husband shot the guy, and in the background on the 911 recording, the wife saying, "Why'd you do that? Why'd you do that?" Mm-hmm. So another way to talk about what's reasonable from the objective and subjective point of view is, as the armed defender, do you think it's reasonable that you have this imminent fear of great bodily harm or death? But if you're a married fella, you might also think, what would my wife do in this situation? I know in my life and everything, usually she has the more reasonable response. Yeah. And it's a good thing because there's going to be a cat lady librarian potentially that is called to serve on the jury if you go to trial.
Yes.
What's she going to think is reasonable? And her opinion counts if she happens to sit in judgment of your decision.
Understood. And both of you kind of touched upon these next two areas that the members have questioned upon. What is imminent danger, and truly explain great bodily harm?
Let me tackle imminent danger. I'll also expand that to imminent threat. Okay. What we're really talking about then is what is the circumstance as an armed defender that you are being confronted with, or what are you facing, and how does that factor into this construct of what is lawful self-defense? Well, we pretty much know what danger is. We pretty much know what threat is. It has to be genuine, a genuine danger and a genuine threat, at least to you. You can actually make a mistake and it still could be lawful, but there has to be this perception of a real threat. And to use lethal defense, deadly force defense to a threat, the threat that you face has to be a threat to your life, a deadly force threat to your own life, or one which could cause serious bodily harm, serious injury. And I'll ask Shawn to expand on that in just a minute. But let's shift over to what imminent means, because that's really the focus of this. Imminent basically means right now. You can't define it, and it's not defined in the law as a certain number of seconds or fractions of seconds. It's really your perception that it's happening right now, that it's immediate.
Yes.
You do still have some time, though, when you're facing an imminent threat to make a decision what to do, and you're allowed to think that through and act appropriately. Now, an imminent threat would be one that you have to address right away. An imminent threat would not be, for example, someone who had a club or a knife that was 100 yards away.
Got you.
Because they just can't hurt you at that distance, no matter how much they want to. As they get closer and closer and closer, it becomes more likely to be considered imminent. And there will be a point in time, frankly, that they'll be close enough that no matter what you do, you can't protect yourself.
Correct.
Because they're just on you that fast.
Yes.
And we've talked about the Tueller research, the so-called 21-foot rule, and how that factors in. So in my mind, there is some place between your perception of the threat, your need to respond, at least to prepare to respond, and then that last possible moment for which you can respond.
Gotcha.
So it's that sort of gray area. And I think if you otherwise act reasonably, as we talked about a minute ago, you're going to get the benefit of the doubt on that.
Yeah, and on imminence, we've seen cases where the defender said, I was afraid they were going to attack me.
Yes.
That's not imminent.
Yes.
He was attacking me, or he was coming at me, and the attack was in process, and I had time to react. That's imminent in that situation.
That's good because, a lot of times, people, they use that catchphrase, about, I was in fear for my life. Like, what does that mean, correct?
Yeah,
So you
yeah.
have to truly, be able to articulate that a little bit more by, explaining the distance and the imminence, correct?
Yeah, I think it's going to come down to your ability to articulate what your thinking was.
Yes.
What were you thinking? Why were you thinking it? And is it objectively, that meaning to the jury, reasonable within the larger picture of what was happening?
And that's why we like the term reasonable belief
Yes.
better than fear,
Yes.
right? Because if I'm in a sketchy neighborhood in a dark alley and some character's coming down, and I could reasonably be fearful of that person, but I'm not justified in using deadly force yet. But if that person shows a knife or a gun or starts approaching me and is telling me that he intends to rob me or hurt me, now my belief that he really intends me harm is now reasonable. And fear or not, the justifiable use of force is the window's opened for that to be there.
And I think also that's why there's so much value in using other skills and techniques to try to determine whether you are in fact in that imminent threat status. Figuring out what they intend. We call it sort of what dispelling the ambiguity. You don't really know, so you can use voice commands. You can try to get some distance. You can go behind something to give yourself more time to evaluate before it truly gets imminent right this second.
Yes.
And I'm glad you brought up intent, because our friend Steve Moses, who's a self-defense instructor, firearms instructor, from a tactical perspective, that reasonable belief that you face imminent threat of great bodily harm and death, that's the legal terminology. But he teaches his students that an aggressor has to have the ability, the opportunity, and the intent to cause that death or great bodily harm. And that's a great way to think of it. Can they do it? Do they want to do it? And do they have the ability to carry out that attack effectively against me? And when all three of those things are together, and that opportunity part means right now,
Yes.
then you can make a decision with a lot more confidence.
Gotcha. And then again, like touching upon the difference between someone just being fearful of being harmed and great bodily harm. Kind of explain that a little bit more about, what does that really mean?
Yeah, you threw that one to me earlier. I'll take it first, right?
Yes.
But I think a lot of concealed carriers need to know that they should have some experience to know they can take a punch in the face. I think everyone should have a little martial arts training if they're going to be a concealed carrier, if they have that physical ability to do that, because you can get thrown around a little bit. You can take a slap in the face and you're not going to die, and you're probably not going to be incapacitated, right? Now, if it's something where they can really pound on you and you're afraid you'll have a concussion or lose consciousness and be subjected to further attacks, now we're getting in the realm of serious bodily injury, right? If it's something that's going to require surgery, if you're going to have to get an orthopedic doctor to be in a cast for a long time, we were talking about almost permanent change to your body. Yes. That's serious bodily injury, right? And so we're not talking about someone pushes you or slaps you. You know, that can escalate, and you certainly need to be on guard. And we're not saying that hands and feet can't cause serious bodily injury or death in the right circumstance. Right. But if you're an armed defender facing off somebody who doesn't have a lethal weapon, you have to really have a strong question about how badly can they hurt me and what's their intent and when do they cross that line.
Excellent.
Yeah, you know, some of that factors into this concept of disparate or disproportional force. Underlying the whole notion of self-defense is that you can meet force with equal force, but not more force than what's being used against you. You can't, in other words, use deadly force to defend yourself against a non-deadly force attack. And if you do, even though you have the legal right to use some force, yes, if you use more than the legal force that the law privileges you to use, then you have escalated beyond what you were allowed to do legally, and you then commit a crime. So if you shoot somebody who has merely threatened to slap you silly, then you have now committed the aggravated assault, the aggravated battery, maybe the murder. Understood. No matter, and even in your mind, you're acting in self-defense. So that's why you really want to get your hands around these legal principles and concepts and know that when you're facing an attacker, your assessment of their ability to do what they even may be threatening to do, maybe even intend to do, is a big part of it.
Gotcha. So another member question is about justifiable homicide. So they understand that, you know, in a self-defense incident, they take a life. It's still considered a homicide. But more specifically, they want to know, the standard for justifiable homicide, does it change state by state?
It does, but not very much. All 50 states have the basic notion for justifiable homicide. Now, I'm going to use justifiable homicide as the same as acting in legal self-defense, because it's really the same concept, especially if someone dies. That's the homicide part. The justifiable means is you had the legal right to do that. You had the legal right to use deadly force even if it resulted in death because of the deadly force threat being used against you. That's self-defense. So how it may change from state to state, there are going to be nuances around, especially in what kind of force can you use against someone committing a crime. Some states allow deadly force against almost any crime that's being committed against you. Others, it's a very narrow, aggravated felony sort of thing, robbery, sexual assault, that kind of stuff. But in the basic context of justifiable use of force, all the 50 states pretty well align, and that's what we've talked about already. If you are facing an imminent threat of great bodily harm or death, you have the right to respond with, and I like to say it this way, you have the right to respond up to and including deadly force. You don't have to use deadly force. If you can use less than deadly force to repel what you reasonably perceive to be a deadly force threat, you're good. In fact, you're better than good because you haven't killed anybody and you've saved yourself.
And now it's not a homicide investigation.
Yeah. Now, since we're talking more 30,000 feet, it makes a huge difference under justifiable homicide or self-defense, whether you are in a duty to retreat state or a stand your ground state, and you better know the difference. Yes. You better know not just in the state where you live, but you better know in the state in which you're traveling, where you might be involved, because if you're involved in a justifiable homicide in a foreign jurisdiction, meaning a state that honors your permit or where you're legally allowed to carry, you are going to be governed, your behavior is going to be measured and judged by the laws of that state, not where you live. So yeah, it differs all around the country, and those are really important distinctions, and it's incumbent upon the concealed carrier to know what the laws are, where they are at any given moment.
Yeah, but all that said, when we write articles
Yes.
about the lessons learned from self-defense incidents all over the country, and duty to retreat states, and stand your ground states, and make my day states, right? If it comes down to it, if you live by the credo that you're not going to use deadly force unless you truly face that, have a reasonable belief of that imminent threat of great bodily harm or death, and you didn't pick that fight, and you're in a place that you're legally allowed to be, that's the basis.
And you can't get away.
And you can't get away. Yeah, even if you're in a stand your ground state, if you make a reasonable effort to get away safely and that failed, right? At that point, and so when we talk about these things, we like to go to the strictest standard, and that's like the most morally just standard, in my opinion.
Yes.
And if you do that, no matter where you are, you're following the best guidance we can.
As Shawn was saying, let me add that if you take the conservative approach, meaning that you avoid a confrontation when you can, that you attempt to retreat when you can, all of that will be seen as acting reasonably by the jury. And that's who holds your fate. Even in a stand your ground state, if the jury sees you made an effort to de-escalate, if you see you made an effort to get away before you used deadly force, that not only is looked upon more favorably by the jury, in my view, but it also strips away the prosecutor's opportunity to say you acted unreasonably. Because even in a stand your ground state, some prosecutors will have the right to make the argument, yeah, he might have gotten away, but what reasonable person who carries life and death in his hand wouldn't take the opportunity to save a life? And you just get rid of all that when you act conservatively right from the beginning.
You get points from the
Absolutely.
jury, sympathy points.
Yeah. Okay, and speaking of the jury, the next member question is, who truly decides if the use of deadly force is appropriate, the judge or the jury?
When you say who truly decides, I say the jury. And the reason for that is I'm assuming the judge isn't deciding whether you're guilty or not guilty. That would be a bench trial, and it would be pretty rare, especially in a homicide case, to put all of those eggs in one basket, especially if there's any evidence, to suggest otherwise that you have to deal with. So the jury is the body. They hold all of the power in deciding whether the prosecutor has proven their case. And if they think that the prosecutor has failed, even by a tiny bit, to prove beyond a reasonable doubt that you didn't act in self-defense, then the lawful verdict is not guilty. So it will be the jury that renders the verdict, guilty or not guilty. So they hold all the power in that regard. And it's going to be at least 6 and probably 12 people that have to be unanimous before you can be convicted.
You know what? But nobody asked the jury, how did they come to that decision?
Good
That's
point.
done behind closed doors, and they can come to any decision they choose on that. And so who decides whether it's justifiable or not? A jury of your peers. And let me tell you, that's not going to be 6 to 12 CCW Safe members. It's not going to be 6 to 12 even concealed carriers or people who own guns. We try to work that out in voir dire. But also, what people need to know about the jury selection process is you don't pick a jury. Maybe they bring in 60 people, and they're numbered 1 through 60.
Yes.
And if you don't do anything, the first 12 people, they're your jury. And so we work with them. We get a little sense of how they understand justice. How do they feel about guns? Do they know people who have guns? And then you get people who are blatantly biased in one way or another. You can tell the judge, hey, I want them out for cause. They're not a good juror for this. And often you fight about that. The judge pops those people out. And then each side gets basically sometimes, let's say, 3 peremptory strikes. And you go back and forth and take turns. And you say, well, I don't like that one. Then they say, I don't like that one. If you run out of yours first, then they're going to load up the next people that you don't like on that jury. And it might be like it might be the cat lady librarian who's end up there. It might be a pastor. It might be a housewife. It might be a school teacher. It's whoever gets sent to the courtroom that day, whoever you got kicked out, the rest of them, they're going to decide.
Let me add, since we're on the subject of who has the power in a case, the accused, the defender, has the absolute least power from the beginning. Once that trigger is pulled, you have effectively surrendered yourself to the system. If the system works right and it was a lawful self-defense, it shouldn't take very long. But that's not always the case. In fact, plenty of people that are acquitted at the end of the process are arrested, spend a year or year and a half or 2 years in jail waiting to go to trial, and just at the end of that process, the jury says not guilty, and they walk out of the courtroom. And they can't do much about it. Even the judge has limited power to dispose of a case or to resolve a case, in that the sole authority to bring a charge is with the prosecutor, the executive authority in that jurisdiction. Judges can, under some limited circumstances, dismiss charges in the right setting, if there's certain applications, make findings that the evidence is wholly unsupportive of the charge, that kind of stuff. But when it comes right down to it, the judge acts more as a referee or an umpire. The prosecutor brings the case and pursues the case and holds the authority ultimately throughout the trial, throughout the entire progression of the case, to dismiss it if they choose. But the the defendor has virtually no authority once they're involved in the system. At the end of all this process, which is likely to take months or years if it's a lethal self-defense case, it will ultimately wind up in the hands of the jury, which is how we began this segment. Of the jury then decides guilty or not guilty. But actually, and we've had these kinds of cases, sometimes they can't decide, because not only does guilt have to be a unanimous verdict, so does innocence. But innocence isn't a very good word to use about the criminal justice system. It means either guilty, meaning the case was proven beyond a reasonable doubt to the satisfaction of all the jurors, not guilty, which means that all 6 or 12 jurors unanimously decided that the prosecutor did not prove their case beyond a reasonable doubt.
Yes.
Even if some think maybe the person's probably guilty or likely guilty.
But they went along with the
They just
majority,
decided,
and they said,
right.
fine, let's do it. Yeah.
And then there are those cases where the 6 or 12 jurors can't decide unanimously on either one.
Mistrial.
And then you've got the mistrial. You've got the proverbial hung jury.
Yes.
Then the judge, after trying and prodding and trying to get the jury to come up with a verdict, because the judge and all the lawyers know that if a mistrial is declared, just start over.
We're going to do this again.
Absolutely.
Sometimes, like in 2 weeks, we'll start again.
Yes.
And if I can, one more thing on the judge. Very often, the judge knows just a little bit more than the jury does about the case. They're learning about all these details at trial, except for the evidentiary stuff that they ruled on beforehand and some
That's
of those
right.
motions. And not all judges have done a lot of self-defense cases that run a little bit counterintuitively. And sometimes I've seen Don have to sort of educate the judge. These are the standards. This is how it goes. This is who has the burden. We're not going to let the burden get shifted. And, it's not a perfect system. We do the best we can.
That's right. So this next member question, it actually came in several different ways, and they didn't give us any information about which state they're from. But they said, what about defending property? Can we use deadly force for that?
Well, let me answer this for the benefit of everyone, including people that live in Texas, because that's the only wrinkle, frankly, because there are some circumstances, narrow, limited circumstances in Texas where you can use deadly force to protect certain kinds of property under certain circumstances. Everybody should just accept that no, you can't and you shouldn't, and hope that they are never put in a position where they have to make that decision, because they should always default to no, give up the TV, give up the car, whatever it is, as long as life and limb are not at risk, let the property go.
Yeah,
and
we
then
talk-
you're safe, and then you're safe.
And in the concept we talk about home defense, you're not defending your home, you're defending the people inside your home. That's what you're defending. And if you can find a hard corner in the back room and someone walks out with some valuables, that's better than committing a homicide in your house, even if you are absolutely justified. And we've talked to some experts. Sometimes we see a lot of cases where someone catches someone breaking into their car and there's something really important in that car. We've seen cases where medals of honor from someone's grandfather who fought in World War II were stolen. If you have anything that's so valuable to you that it cannot be replaced and you'd consider fighting for it, put that thing in a safe, put it somewhere where it's really hard to get to. And even then, alas, it's not worth facing the consequences of a homicide to save that thing.
And that's easy to say, and it's legally correct to say that.
Yeah.
It doesn't make you feel very good necessarily, because people get so angry when they are violated like that. When someone has the audacity to break in their house and steal something of value, or just, even if it's not of value, just the betrayal of civilization for people to do that, it makes you want to shoot them. I would want to shoot them.
Yeah, but this isn't the Wild West, is it?
No, and if you can't resist the impulse to do that, then you are going to put yourself in the crosshairs of the prosecutor, who's going to say to the jury, there is no property worth killing someone over. And there's going to be 12 people on that jury, as Shawn said, maybe few of them are concealed carriers. Some of them probably can't stand guns. Some of them are so scared that they couldn't even hold one. So yeah, you don't want to put yourself in those folks' hands if you can possibly avoid
And we've seen cases where people have used deadly force to protect property, and they realize very quickly that they regret it. And they regret it for the rest of their lives.
So you just can't let your ego and your pride and all of that poison your reason and judgment in those highly emotional situations.
Absolutely. I mean, you can replace property, you can't replace lives, regardless of,
And society, for good reason, values all life. You can't say that some people...
Even jerks.
Yeah, the jerks get to live another day too, unless they are posing that imminent threat of great bodily harm or death to you right now, then they get to live too.
Awesome. So this one here is from one of the trainers, okay? They ask, how do you ensure that your training aligns with the legal standard for the use of force in a self-defense situation?
That's an interesting question. I think, we've had some experts that we've talked to who are such great trainers and instructors that they're called to testify in court about use of force, right? And so you want somebody who is serious about it. I think you want somebody, we talk about the idea of conservative, someone who takes a very careful approach to it, that exhibits that they have a respect for life, that they don't have this prairie justice sort of, the bad guys deserve it and we're going to be ready for it when they get there, and that they're focused not just on the mechanical, tactical skills of pulling your pistol and shooting a target, but also you want someone who's going to talk about de-escalation. You want to talk about someone who's going to talk about preclusion, someone who talks about less lethal options. And if you have an instructor who has that mindset, then I think you're getting good instruction. And then on top of that, just technical proficiency with the tool. I think you are in good hands.
Well, I think this goes to this notion of the two fights that you have. Yes. You have the first fight for your life, and you need to have the tactical training and the operational proficiency to defend yourself. And whether that means making the right choices as to how you are armed, giving yourself options, being smart enough to know that time and distance create options, and all of that smart stuff when the goal is for you to stay alive. And the other goal is for you not to take a life unnecessarily. The other part is the second fight, and that is if you are involved in a lethal self-defense, because that's the highest stakes there are. That's when you're likely to be charged with murder, where a bad outcome means you could spend the rest of your life in prison. So it doesn't get much higher than that. So the stakes don't get higher than that. So that's what we characterize as the legal fight.
Yes.
And you want to position yourself through your training to be in the best spot to win that fight too. So that means knowing things, training in areas that help you understand the legal boundaries, the things you can do and can't do, the notion of proportional force, the idea that maybe you might take a slap to the face and be willing to take it and not shoot somebody in response. Understanding the laws of your jurisdiction, where there might be a duty to retreat, et cetera, et cetera. So you have to have the tactical proficiency and the tactical smarts that goes along with that, but also a comprehensive understanding of where the lines are that you don't cross inadvertently, because you just don't know where that line is.
And then the ability to articulate why you crossed those lines when you had to make those decisions. When you make your self-defense claim, if you're able to explain how you tried to de-escalate, how you tried to get away, and then that you had no choice after that, that's much more impressive to the prosecutor who comes around, the homicide detective comes around, and ultimately a jury if you have to face that.
Awesome.
And well, let me add one more thing. When you are involved in a self-defense scenario, you have to own it. I mean, what you did was purposeful and intentional with the goal of saving your own life.
Yes.
Whatever force you used was in response to a threat of force or the use of actual force, all the way up the scale from non-lethal to lethal. And when you act in response to that, if you want it to be called justifiable homicide or self-defense if you take a life, it's because you did what you did on purpose for the goal of saving your own life in a situation where you are allowed to do that legally. So don't make things worse by saying stupid stuff,
Yes.
like being afraid that when you shot somebody on purpose, that maybe it would sound better if you said, well, it was just an accident. The gun went off accidentally.
Yes.
Or undermining what a self-defense claim is. Making inconsistent statements to the police because you want to try to make yourself look better. Those kinds of things factor into what's going to happen moving forward after the self-defense incident and how you're going to be perceived and portrayed, and ultimately when your fate is in the hands of the jury, how they're going to see you. Did you act reasonably and appropriate in a situation that truly was life-threatening?
All right. So the next member asked the question, can you provide an example of a recent court case involving self-defense and how the outcome was determined regarding justifiable homicide? So just recent or one from the past.
Every case, there's a determination of justifiable homicide. I'll use one that we explored recently out of Michigan, Lapeer, Michigan. There was essentially a road rage incident that ended up turning into a deadly altercation in a parking lot, right? And this is interesting because the defender was actually attacked by a guy who was high on cocaine, wielding a crowbar and trying to hit him with the crowbar. Right? And that looks like a pretty cut and dry. A crowbar is a deadly weapon if the person has the intent. He certainly had the ability, the opportunity, the intent to do this.
Yes.
But then you find out that they had already had a little spat, and the defender came back to the parking lot to confront this guy. And then there's some evidence to show that this guy may have pulled his gun on his attacker before the fight started, provoking the attack.
Yes.
And then you find out that this guy had texted a friend just weeks before, oh, look, I got this Smith & Wesson revolver, for convenience stores. He was anticipating he'd have a fight in a parking lot at a convenience store.
Yes.
And then he did, and he shot a guy, and the jury convicted him in an hour and 30 minutes. So what looked like a reasonable use of deadly force on the surface, he had done things that undermined that,
Yes.
that caused the jury to feel he's not reasonable because he was looking for a fight. He came back to it, and he was the first aggressor. Boom, case closed. He's in jail.
We see a fair number of those in the news. We look out for them, frankly, because when you first see the reports, they look like pretty good cases of self-defense. At least there's a pretty clear pathway to a self-defense claim. And then as more information is revealed, you learn that they posted on things on social media that were inappropriate, made them look like they were looking for a fight, looking for a confrontation. If you really think about self-defense cases as they play out in court, your goal is essentially to establish what you did and why you did it. Yes. Really, what were you thinking? And if you were thinking that I'm facing a deadly force threat, and that thinking is perceived as reasonable by the jury, and that your response to that deadly force threat was appropriate, and the jury thinks it's appropriate, yes, then you're acquitted. But they really are looking inside your head to decide what you were thinking when you did what you did. Well, if the prosecutor can go outside that and claim things that you said before or after, things you posted on social media, those kinds of things change what you were thinking to a predisposition, yes, for example, then it changes the whole balance of stuff. And we've seen those cases in the news. We see them regularly where weeks or months later, social media posts come to light, or information maybe that the police, through investigation, found out that wasn't immediately known. Change, and it can go just like that quick.
It changes the whole
case. Thing can turn on a dime, and a decent self-defense case becomes, a 25-year prison sentence.
And for the benefits of the people listening, I want to give you another case where it was a close call, but the jury acquitted the defender, right? And this is Curtis Reeves. He's in his 70s. He's going to a movie outside of Tampa, Florida. The guy in front of him yakking on his cell phone, being loud and obnoxious. He tells him, hey, can you put your phone away? He doesn't right away. Some things happen. Anyway, he says something snide to the guy after his phone was away. The guy just explodes. He stands up, leans over his chair, smacks Curtis's popcorn out of it. And he's like this big, robust, healthy 42-year-old guy. Yeah. And Curtis is this retired police officer, frail, and this guy's just exploding on him irrationally. And he was terrified. I think rightfully terrified. Now, was that threat great bodily injury? Was it as imminent as he thought? We don't know, but he pulled his pistol and shot him. Yes. But even the 40-year-old guy, like, his wife was trying to hold him back. He actually shot this guy through his wife's hand who was trying to hold him back. She thought he was being irrational too. Yeah. Anyways, he's prosecuted. He goes to trial. Pretty good case. I think it was well defended. But while they're waiting for the jury to come back, Curtis takes his wedding ring off because he wants his wife to have it, because he believes he's got a really good chance of going to jail. It turned out they spent a lot of time talking about just how frail he was and how unprepared he was and vulnerable in his chair to defend himself in any other way. Yes. And so even though he used disproportionate force, because of the position and how healthy the young guy was and how frail he was, the jury gave him some credit. And I think also because he was a veteran of the police force.
Yeah, and I think he had good human credibility, as a decent, upstanding
people felt
guy
sorry enough for him that even if he made a
society.
mistake, he didn't deserve to go to jail.
And when the actual shot was fired, he was sort of trapped in his seat. However, what gave a lot of people pause was he had plenty of chances before the end of the sequence to get up and move.
Yeah, they weren't assigned seats. He could have just gone a row back, or
And he went and reported the guy to the management. And so, yeah, it would have been just as easy. And did his ego or pride or stubbornness prevent him from doing that? Could he have avoided the whole thing by saying to his wife, come on, let's just go over there and leave this guy to himself? Too much cop in him, I don't know. But he didn't do that. And fortunately, as Shawn pointed out, it was a hard litigated case. It took a long time. At the end, the jury... Now, what the jury decided which is something to remind, I think, our members of. The jury didn't decide that Curtis Reeves was innocent. What the jury decided was the prosecutor didn't prove its case beyond a reasonable doubt, meaning that the prosecutor didn't prove conclusively that it couldn't have been self-defense. So if there's some plausible claim supported by some evidence that it was self-defense, then the proper legal verdict is not guilty there. And that may be where the jury wound up. We could say, I don't think I'd have done that, but I can't say that it wasn't, in his mind, self-defense supported by facts and evidence.
Gotcha. And to your point you made earlier, it's not always about innocence, right? So, yeah.
Oh, keep in mind that's a Florida case, and Florida now, with a lot of other states, have a self-defense immunity system. And for those that aren't familiar with that, it's an idea of being able to address self-defense issues before the judge prior to the beginning of the criminal case with a jury. So you have a mini trial, in a sense, and the states change from state to state who has the burden of proof and what the standard of proof is and all of that. But at the end of the day, when you have a right to claim self-defense immunity, if the judge agrees, then they have the authority to dismiss the charge.
Correct.
Well, in this case, they went through that process, and the judge did not dismiss the charge against Curtis Reeves. So he fought that battle and lost, which I think may have been some reason that into his thinking at the end of the
this might not go my way.
Yeah. So.
And that too is the power of CCW Safe, because we'll cover that, as part of just the process of the pretrial, correct?
Yes. Okay. Yes, and many cases are resolved that way through that process. And aggressive, effective discovery. CCW Safe pays every nickel of what it takes to interview potential witnesses, pay for transcripts, pay for expert witnesses. I personally was co-counsel on a protracted, extended self-defense immunity case. And it took a full week. Meaning there's no jury, so there's no jury selection. We had 40 hours plus in the courtroom. There were over 100 pieces of marked evidence. I think there were 40 witnesses that testified.
And full media coverage the whole week. Yeah.
So it's the real thing. And if you have the opportunity to take advantage of it, you sure want the resources to be able to do it, because, and it's pricey. It's not like you can throw an extra $5,000 and we'll do the immunity hearing.
Yes.
You pay a couple of lawyers and you put your experts on the stand and you collect, and you prepare it just as if you're going to trial.
Yeah.
It's,
and you pretty much call it a mini trial. It's
Kind of how the same, just no jury. Yeah.
Okay, guys, so the last question for this particular part of the series, what steps can we take to educate ourselves and others in our community about self-defense laws to promote responsible gun ownership? You both can answer if you want.
It's funny. I think Don mentioned earlier, it's incumbent upon every concealed carry armed defender to go look at the statutes in their state and know what they are. They're written by lawyers, for lawyers. They're a little bit confusing. So I think that it's important. What I love is that we've got so many resources for CCW Safe that talks about practically how do you apply that. Familiarize yourself with those. Look for news reports about self-defense cases, right? Follow a couple cases, because you will see what defenders did right when they're acquitted or there's no charges, and what they did wrong when they face charges or they're convicted. And what that does is it comes down to visualizing scenarios where the use of force might be justified. And I think a lot of people go into it thinking, oh, if someone plows through my front door and comes to my house, then I'm going to shoot him.
Yes.
Or I'm going to be approached by a guy with a knife in an alley and I'm being mugged and I'm going to shoot him. We have very clear-cut circumstances in our mind. What we don't think about is like the guy in the car behind us getting out at a traffic light and acting crazy and escalating into where we don't know how to handle this person because they're not acting reasonably, and then we find ourselves afraid and we never imagined this situation. So if you look for self-defense cases in the news, and we'll bring you plenty of those on CCW Safe, then you can visualize circumstances that you might not have anticipated, and you can think, what would I do? What would I have done in that situation, and would I have made the wrong decision? And you can correct that thinking, that mindset.
Gotcha. You want to add anything now?
Well, I think Shawn's really hit on something that it's easy, I believe, to think through stuff if you've been exposed to it and had reason to think it through. What a lot of new gun owners, I think, wind up in the position where they're concerned enough about something that they want to get a firearm, they want to get a permit, they go to the training that comes with the permit class, but maybe they don't go much beyond that. They may even go home and put the gun in a drawer or leave it in the glove box and think that they're now prepared to deal with a deadly force threat of some kind. So we certainly encourage all of the additional training that you can get, but there's an idea when you listen to our podcasts, watch the videos, look at the written material of us and others. There's some great books out there to read. It's going to give you an awareness of the things you should be thinking about.
Yes.
And all you really need to get started is an awareness of the things you should be thinking about. And once you start thinking about those things, that will help inform you on how to put it in practice. Well, oh wow, I never thought that home defense should include getting a good lock on the door, or getting a door that some knucklehead can't, kick down with one half-hearted attempt.
And remembering to lock it, actually.
And remembering to lock it, sure. Those kinds of things. Once you go through that process and start thinking about personal safety and how that extends beyond the firearm, you will have the mindset of the defender. You'll be more self-confident that you'll be able to handle a situation. And as a result of that, you'll be a more responsible and safer concealed carrier.
And let me give you a concrete example as we wrap this up, Stan. We covered a case, Ted Wafer, in Dearborn Heights, Michigan. Middle of the night, someone pounding on his door furiously, frantically. He couldn't find a cell phone. He's panicking. It just sounds like they're trying to break through this door. He grabs a shotgun. There's like a little pause. He thinks he's going to go investigate. He opens up the front door. He's surprised to see this figure there. The trigger's pulled, blows this girl's head off. Teenager, just graduated high school, was a cheerleader. She happened to be drunk, high, and had a collision, a single car crash. It hurt her head. She was disoriented. She probably thought this was a friend's house or was looking for help. He didn't know, but he had this catastrophic thing. And so our advice was he would have been better off just to find his phone, call the police, wait, find a safe place to wait. If they get through the door, it's a whole different ballgame, right? So don't open the door. Don't go outside to this, right?
Don't shoot through the door and don't open the door.
Yeah. And so we wrote about that. And so we got a year later or so, we got a member reach out to us and said, it was late at night. My family were all sleeping. This crazy guy with no shirt and no shoes banging on my front door. He said, I remembered your article. Call the police. Don't go outside. And he actually communicated with this guy through the glass. Said, if you come in my house, I will shoot you. And the guy threw stuff at the windows. He tried to get in the doors. He never did. The police showed up before he had to use deadly force. And now he doesn't have to live in this house where he shot a guy on his front porch. And it was because he had imagined that circumstance before. His was a little bit different, but he was able to adjust his thinking and make a choice that saved a guy's life and saved, I don't think he would have been prosecuted in this case, but it saved him a whole lot of heartache and trauma for his family.
Sure.
Well, thanks. So guys, in closing, on that note, work with your families on an emergency plan in the home. If someone does come to your front door, kick in your door, have a secondary plan to get out, just emergency plans to work, okay? So do that. Thank you, Shawn, Don. This is the end of part one. We have 3 more parts to this series for answering the CCW Safe members' questions. Keep your questions coming to support@ccwsafe.com so that we can continue to do more of this. I hope you guys enjoyed it, and be safe out there.